Nick Rekieta is a Minnesotan lawyer who you might know more commonly as Rekieta Law, a popular YouTuber with over 440,000 subscribers. Rekieta rose to YouTube fame covering popular trials like Rittenhouse and the Depp Heard trial. And a week ago, he and his wife were arrested and charged with second-degree possession, a gross misdemeanor firearm charge, and child endangerment. So let's break it down. We'll start by taking a step backward and going over what went down pre-arrest. Why was Nick Rekieta arrested? Well, because of what they found when searching his home. Why'd they search his home? Well, according to the application for a search warrant filed by a detective at the Candy-Yoho County Sheriff's Office, if I'm not saying that right, get down in the comments and let me know. I don't know how to say Candy-Yoho. The Sheriff's Office received a report from an unnamed source that 4 people from their church had gone to him reporting neglect to the children, possible controlled substance use, and a questionable relationship with an additional couple. As an aside, it's very clear that there was a mandatory reporter at this church who got this information about children who were in danger and who had to report them. And that's why you can have a search warrant that is predicated on a report to someone who is not an eyewitness to the things in the report. The report included claims also that Rekieta's children had complained of being hungry, not being fed, and wearing the same clothes for 3 to 4 days at a time, as well as marked changes in Nick and his wife's appearances and demeanors. The application then goes into the detective's own account of reviewing Rekieta's past live streams and the live streams of close friends and fellow bloggers April and Aaron Imholt, noting Rekieta's changed appearance, moments when Aaron Imholt mentions recent experiments with drugs like Molly and cocaine, and even saying Rekieta should get help for substance abuse. Look, lawyers everywhere are just shaking their heads at this point. I get it, the world is changing. I mean, pervasive video, and certainly web-hosted video, is relatively new in the history of the law. Honestly, bloggers and social media addicts and just regular morons are making police work, at times, easier every day. The idea that a criminal would use video to document the commission of a crime is something new for humans. And also, it's a crazy thing to do. Full stop. But then to go on and take that next and added step of posting the video online where either anyone can see it or a group of people can see it, that's a very foolish thing to do. Unless you want to get caught. And honestly, I think a lot of people do want to get caught. They get tired of being trapped in their vices and in their miserable lives. Videos that tend to show probable cause for the existence of a crime are the low-hanging fruit of the police world. It can make it very easy to get a search warrant because, absent fears that a video is doctored or is otherwise misleading, the judge reviewing the warrant application doesn't even have to really trust the police officer or investigator. It's just like, yeah, go watch the video and see for yourself. Not that it's ever been hard in the US to get a search warrant, because remember, the standard is only probable cause, not beyond a reasonable doubt. Whereas beyond a reasonable doubt might mean like 96 to 99% sure, probable cause is perhaps in the high 30s or low 40s in terms of percentage of confidence that something is true. So you don't need super strong evidence, you just need some evidence. And videos are definitely some evidence. Some strong evidence, sometimes. As we all know, based on the information provided in this request, a search warrant was granted to the Candy-Yoho, yeah, I said it again, the Candy-Yoho Sheriff's Office, which leads us to last week. Thanks to the statement of probable cause, we have an in-depth play-by-play of what exactly went down. The statement asserts that upon knocking on the door, a juvenile female opened the door and wouldn't let them in. Now, that could be good parenting. Most parents tell their kids not to open the door for anyone. Nicholas Rekieta would not provide the door code to enter the residence. Now, that's not the same thing as a child telling no to another adult. Rekieta is an adult and he's an attorney. And if he can see that they appear to have a valid search warrant and he refuses to give them the code, then that could be viewed as obstruction. If he doesn't know about the search warrant, then he's not going to be charged with obstruction. If the police knock on your door and they ask you if they can come in, the best way to find out if they have a valid search warrant is to tell them, no, you can't come in. If they do have a search warrant, step back away from the door because they're probably about to bust the door down. As I was saying, law enforcement entered the Rekieta home utilizing a door ram. Officers noticed that the home was extremely cluttered. Now, that's not a crime. I mean, that's what my home looks like some of the time. There were clothes everywhere, dirty dishes, dust, and an overall dirty home. That's not a crime. It's not great. It's not a crime. The statement then lists what the search produced. Several containers and vials that tested positive for cocaine and multiple baggies containing cocaine, ketamine tablets, drug paraphernalia, and firearms and ammunition, which leads us to the charges. The first charge is drug, second degree, possession of 25 grams or more of cocaine or methamphetamine pursuant to Minnesota Criminal Code Section 152.022.2, subsection A1. Dealing cocaine or meth under this statute is a violation if it's more than 10 grams, but possession alone is the same crime if the threshold weight or mass of the drug exceeds 25 grams. And they had more than that here, but just barely. And that's problematic because the penalty is very, very harsh. Subsection A says a person convicted under subsection 2 may be sentenced to imprisonment for not more than 25 years or to payment of a fine of not more than $500,000 or both. And subsection B says if the conviction is a subsequent controlled substance conviction, a person convicted under subdivision 1 or 2 shall be committed to the Commissioner of Corrections for not less than 3 years nor more than 40 years, in addition to being sentenced to the payment of a fine of more than $500,000. If you're following along, that's up to 25 years for the first offense and up to 40 years for the second one, and a guaranteed 3-year minimum no matter what on the second one. What makes this so harsh in some ways is that hardcore possession, like what you would have if you were just like a total addict, is punishable just as severely as being a lightweight dealer, at least as the law is written on the books. Now, the reality is that in almost every state, including in Minnesota, there are diversionary laws that allow for people who've been charged with a drug crime that is not a crime of violence to be diverted into what is functionally a treatment program, while also having the full weight and potential incarceration behind the enforcement of the program. What this means is that if the defendant does not engage in the treatment program effectively, they may find themselves in prison for a long time. Now, whether the prison system is an effective or even an ethical solution to the problem of drugs and drug abuse is definitely an open question that it's being constantly debated in Western countries. And for the few Europhiles in my audience, you likely know that many countries in Western Europe do not now currently treat possession of drugs as a crime in the traditional sense. But here in the good old US of A, we still do. I mean, at least on the books, we do. The second charge Rekieta is facing is possession of ammunition and any firearm while being a user of a controlled substance pursuant to Minnesota Criminal Code Section 624.713. Now, Part 3 of that statute provides that users of drugs in Minnesota can't possess firearms, and the penalty is not necessarily a slap on the wrist. Subsection A says that a person named in Subdivision 1, Clause 1, who possesses ammunition or a pistol or semi-automatic military-style assault weapon in violation of that clause is guilty of a felony and may be sentenced to imprisonment for not more than 5 years or to payment of a fine not more than $10,000 or both. This is a simple statute and the elements are very straightforward. If you get charged with this crime, it only ever doesn't result in a conviction with the facts as alleged here in this case if and when a plea is reached, because this is a simple charge and it's a simple conviction. Now, the last criminal charge for Rekieta and the others is child endangerment pursuant to Minnesota Criminal Code Section 604.378.1, subsection B2. Here's what this statute says. A parent, legal guardian, or caretaker who endangers the child's person or health by knowingly causing or permitting the child to be present where any person is selling, manufacturing, possessing immediate precursors or chemical substances with intent to manufacture or possessing a controlled substance as defined in several criminal code sections is guilty of child endangerment and may be sentenced to imprisonment for not more than 1 year or payment of a fine not more than $3,000 or both. However, it goes on to say that if the endangerment results in substantial harm to the child's physical, mental, or emotional health, the person may be sentenced to imprisonment for not more than 5 years or to payment of a fine not more than $10,000 or both. As you can imagine, the presence of children around drugs and firearms is an exacerbating condition that makes every situation that's similar to the one alleged here more problematic. Because Mr. Rekieta does not have a prior criminal history, I can imagine a scenario in which a talented criminal attorney who is representing a repentant and reformation-minded client could easily strike a deal that would allow for the defendant to get the treatment that they need without having to go to jail or prison. Honestly, I'm thinking of YouTube attorneys who could do this. Right now, I'm thinking of Minnesota criminal lawyer Bruce Rivers. Look at that guy. He literally would be the best attorney that I could imagine in this situation, given his familiarity with the prosecutors all over this state and the criminal courts in Minnesota, and his ability to understand the life pressures of not only attorneys, but also of YouTubers. And I feel like Mr. Rivers would be a great attorney for Mr. Rekieta. I would not, on the other hand, recommend that Mr. Rekieta try to hire me. I'm not a criminal attorney. Employment cases, injury cases, class actions, sure. Criminal work, not so much. I don't think Attorney Tom would be a good fit here either. Honestly, there is one YouTuber I think would be the most terrible attorney to represent Nick Rekieta and the other two defendants in this case. And I'm not talking about Legal Eagle, who obviously has politics that don't align with those of Mr. Rekieta. That's fine. Attorneys represent clients with whom they disagree on very many issues, and it's not a problem. But Legal Eagle is not experienced, to my knowledge, in the realm of Minnesota criminal law. And I'm not talking about Emily D. Baker, who used to be a prosecutor. Even though these are quite talented people and wonderful attorneys, bad fit in this instance, I think. Neither of them would even come close to comparing to the person that I think is the worst choice for an attorney to represent Mr. Rekieta and the others in this case. I believe it was Abraham Lincoln who said that the lawyer who represents himself has a fool for a client. And on that note, there's a very interesting, even troubling development in this case, and that's that Mr. Rekieta revealed during his arraignment that not only will he be defending himself pro se, but he will also be representing his wife and April Imholt before she was released without being charged. OMG. This sends the absolute worst message to the prosecutor. The prosecutor wants to see that this lawyer respects the system enough to get himself a lawyer. I would like to think that Rekieta was still operating in a drug-fueled haze when he said that he would represent himself. Nick, if you are watching, hire Bruce Rivers. Look, hire anyone. Do not represent yourself. Don't make things worse. Rekieta's next hearing is set for August 20th, and at that time, we will know more information about how this case will proceed. In the meantime, drop your pro se opinion on his arrest down below. What do you think of the charges brought against Rekieta and his wife? What YouTube lawyer do you think would best handle his case, theoretically? Let me know what you think, and make sure you hit the subscribe button so you don't miss my next video, and I will see you then. Then list the search, Officers noticed that the door... Methamphetamine?